Is there a trump card in estate planning? So a trump card is essentially a term, it came up as a term used in card games for a card that can essentially outrank and outplay any other cards that it's against, therefore giving that particular player a winning advantage. Or when you play this card, this is what's going to come out on top of any other card that can be played. Okay, so in estate planning, a trump card would occur when a certain designation on an asset would outweigh anything else that you might have written or directed about that asset. So is there a trump card in estate planning? Essentially, yes. And this is why this is important to know about, because I think this is something that does not get discussed enough in estate planning. So when you go and sit down with an attorney, or even if you're just considering yourself, what's the best plan for your assets in the future and what should happen to your assets after you pass away, it's really important that things align and all point in the same direction. So I'm going to give you one example here of how this trump card can work. So let's say you create a will and you say you want a certain percentage of your assets to go to one child and a certain percentage to go to a friend and a certain percentage to go to another child. Yet you put specific beneficiaries, or POD, stands for pay on death, people on your accounts, right? On your financial accounts or on your bank accounts. So does one outweigh the other? And the answer is yes. So despite what you might have written in your will, and maybe you took all this time coming up with these percentages and you thought it through really well and you knew exactly who you wanted to get what, but if your beneficiary designations on your account don't align with those specific percentages, and sometimes they can't, because sometimes you're only allowed to list one or two beneficiaries depending on the bank or financial institution, then your beneficiary designations or your POD designations will outweigh what you write in your will. So the will is basically going to be useless against them. It won't stand up. Similar to if you think you're going to win a card game and then someone throws down their cards at the table and you're shocked to see like, oh gosh, I didn't see that coming, right? So you don't want to be stuck with that in estate planning. So it's important to note that although you're going in maybe to see a professional and you're talking about what you want to have done with your estate, and you might actually even spend hours thinking this out and planning it, and you carefully word everything that's written in your will, if all the arrows don't point to that same direction, meaning the exact percentages that you wrote out don't also line up with what you put on your assets, on your bank accounts, on your financial accounts, here in Florida on your home, because you can put a beneficiary on your home using a ladybird deed. If those don't match up with your will exactly, then what is stated in your will is going to take a back seat. And whatever you actually listed on those forms when you wrote out who you wanted your beneficiaries to be and in what percentages, that is going to prevail. And I see this all the time. People are thinking, oh, well, I did the will later, or I did this later, so this is what my estate plan is now. That's not how it works. So you have to be very, very mindful of beneficiary designations specifically, because this can happen. Another way it can happen is by adding a joint owner to your account. I harp on this all the time with people. Unless it's a spouse, I never recommend putting a child or a friend or someone else on a checking account or a savings account as a joint owner. One, it gives them access to that account immediately. So theoretically, they could just go in and start withdrawing money. Two, if they get a judgment or something against them, that's their asset. So now your asset, since you added them to it, became their asset or both of your assets, and it could be subject to the claims of creditors. So that would be a really bad thing. Third, I see this all the time where one child gets added onto a joint account for convenience sake. You want to have a child who can pay bills if needed or pay for medical expenses. Then you think, because I put in my will that that account ultimately needs to be split up between your 3 children. That's not how it works. If you have a joint owner on the account, it goes to that one child 100%. The will does not override that. So the will doesn't come into play and say, okay, well, now that this one child has the account, they have to split it between the other children. That's not how it works. The child can choose to just keep that account if you made them a joint owner. So these are just a couple ways that if you don't have everything lined up, everything working together and pointing in the same direction, in estate planning, you can get an unintended result. So it's really, really important when you go and speak with someone about estate planning, or if you're planning this out on your own, that you make a list of everything that you own and you make sure that all your directions line up. Your will lines up with your beneficiary designations, right? You have everything listed the way you want it to be listed. If it can't work the way you want it to work with beneficiary designations, then you look into a trust and you talk to an attorney about preparing a trust. But point being is, if things are not aligned altogether, one is going to win out. And if it's not the one you wanted to win out, then your plan for the future isn't going to go as intended. All right, so I hope this adds a little bit of value to those out there thinking about doing estate planning. And if you're in Florida and you have any questions about this at all, please don't hesitate to contact our office. We're at Cause Law Office, the non-stuffy attorneys, and the link is in my bio.